Welcome, everybody. Welcome to those in the room and those joining us online. My name is Eloise Scotford. I am the Dean of the Faculty of Laws at UCL and co-director of the Centre for Law and Environment. It is my absolute pleasure to invite this wonderful audience of practitioners, people from government, people from regulators and public bodies, from academia, and our students, my fellow colleagues, to the fourth in this series of really wonderful events that we have co-run with the Green Alliance since we contemplated the prospect of Brexit, since it's happened, and now 10 years on from Brexit, and what is happening to environmental law is the general thrust and theme of these sessions. We have a very, this programme tonight has been organised by Ruth and my colleague, Professor Maria Lee, who have, I think, refined the efficiency of these panels. So we will have a panel for an hour that I'm chairing, swiftly followed by the second hour, another panel. Both of those panels will have Q&A, and then there will be time for drinks afterwards. So it is my pleasure to introduce the first panel, who will be speaking on various aspects of where we are at the moment in environmental governance 10 years on from Brexit. First, we have Ruth Chambers, who I think has spoken at each of these four. Have you spoken at all four of these events? I think you might have. Who's a senior fellow at Green Alliance and has been part of the brains behind this wonderful collaborative event. She has been working at Green Alliance since 2017 to lead the sector's the environment sector's work on shaping the post-Brexit legal and policy landscape, first through the Greener UK Coalition, and now working with a dedicated unit on legislation and governance. And I think the work's just kept on coming. Also, lots of other important roles. Honorary Professor of Practice here at UCL, an advisor to River Action UK and the RSPB, and chair of the national charity Food Rise. Richard McCrory, my colleague, Emeritus Professor at UCL Laws, the founder of the Centre for Law and Environment. He joined this faculty in 1999. He's had many roles in environmental law, board member of the Environment Agency, founding editor-in-chief of the Journal of Environmental Law, long-standing involvement with UCALA, of which he's now a patron, honorary Queen's Counsel. I think particularly relevant for tonight, until recently a board member of the OEP, and that followed key interventions in the kind of debates around environmental law post-Brexit as co-chair of UCALA's Brexit Task Force. Then we have Sally Randall, Director General for Environment in the Department for Environment, Food and Rural Affairs, and was appointed to that role on the 14th of October 2024. Before this, she's had various roles in DEFRA, and since 2019, I think you have been working in DEFRA, and floods and water, environment quality, food, biosecurity and trade, all of these different things have been under your leadership, and you're very welcome. It's wonderful to have you here this evening. And then Professor Ellen Stokes from the University of Bristol. Ellen is a Professor of Environmental Law at the University of Bristol Law School, where she's also Deputy Head of School and co-director for their Centre for Environmental Law and Sustainability. She teaches and researches environmental law, has a long-standing interest in how legal rules, institutions relate to futures, and in particular is doing very relevant work for tonight's session on the relationship between law and hope. So I am going to hand over first to Ruth.
Thanks, Eloise. Hope everyone can hear me okay at the back. Great. So I'm going to set the scene by asking why are we here, why that matters. Then I'm going to do a speedy horizon scan across the four nations and then leave you with a parting thought in about 6 minutes. I apologise for the pace. So why are we here? Why do we keep coming back? As Eloise said, this is the fourth of these events. It's not the free wine and crisps that are waiting for us upstairs, although they are very welcome. Thank you, Eloise, and happy bicentenary. I believe we keep coming back because we care. We care about the laws and the systems that protect and improve the environment, but also because we are, or we aspire to be, actors and not bystanders. We are an eclectic and powerful mix of practitioners, campaigners, academics, students, experts, officials, funders, and more, and we each have a part to play, and thank you for all that you do. So why does that matter? Well, it matters because ecosystem collapse, climate breakdown, and biodiversity loss will have fundamental consequences, including for our national security, food production, and planetary equity. Nature's decline can feel out of sight and out of mind, but it is currently all too visible, with heartbreaking images of washed ashore puffins, a stark reminder of the link between our climate, our natural world, and our own well-being. It also matters because accountability, and by that I mean the rule of law, parliamentary scrutiny, oversight by bodies like the Office for Environmental Protection, Environmental Standards Scotland, or the new Welsh body, a little bit more about that anon, and civil society activism, accountability is a cornerstone of our democracy. And our democracy is the bedrock of our dream for a free, fair, and inclusive society. And our accountability tools and systems will, I believe, both gain in importance and come under increased attack as our politics becomes more turbulent and febrile. And of course it matters, and this is now a more obvious point perhaps, that since Brexit, we've got a much greater degree of self-determination and responsibility on our environmental laws. And yes, there are some guardrails in place, like the UK-EU Trade and Cooperation Agreement. And yes, we are signed up to many international agreements, although some of those, like for example the Aarhus Convention, have come in for some attack recently. But ultimately, the buck on environmental law now stops with us. So that's why I believe we are here. So what's the state of play across the four nations? So starting off in England, I'll do it in alphabetical order for fairness. Our governance systems are indeed maturing. The Office for Environmental Protection will soon turn 5, and we have the Chief Exec here, so you can wish her an early happy birthday in the drinks. Environmental principles are embedded in important places, such as the Treasury's Green Book, although they still suffer from a transparency blind spot. There's an improved environmental improvement plan, and 2030 nature targets are getting closer. As I said, these are headlines only. Progress has, though, been undermined by a somewhat chaotic and anti-nature rhetoric in some parts of government, at least some of which is inspired by a growing chorus of neoliberalism. So in short, there's much to play for over the next year, with a very busy policy pipeline coming up. We know that the government response to the Fingleton nuclear review is perhaps imminent. Details of government's future plans on biodiversity net gain are coming down the track. The land use framework, which should provide the where to the what of the environmental improvement plan, environmental delivery plans that came out of the Planning and Infrastructure Act, and the new legislative programme. We don't know when that will arrive, but we expect it around May, and much, much more. So a very busy time. Moving to Northern Ireland, there has been some welcome progress. The long-awaited Environmental Principles Policy Statement is about to emerge from its final days of scrutiny in the Assembly. And while progress on environmental goals is definitely not where it needs to be, there has been a refreshing honesty about this from DAERA, the Environment Department. A recent review followed in the footsteps of its predecessors and recommended an independent environmental protection agency. And the pollution that blights Lough Neagh and the eye-watering illegal waste dump at Maboy bear witness to why this is needed. And yet, objection from one political party is preventing this from moving forward. It's also important to note that Northern Ireland will soon be the only country in the UK without legally binding nature recovery targets. Scotland, so the Scottish oversight body, Environmental Standards Scotland, will also be 5 this year, and it will have a new role in overseeing the nature targets that's going to come from a brand new piece of Scottish legislation that was passed at the end of last month. Some, though, have suggested that ESS should make more active use of its enforcement powers. In Parliament, Scottish MSPs have continued to push for ambition, insisting on stronger protection for Ramsar sites, removing sweeping powers that the Scottish Government wanted to take to change laws relating to environmental assessment and habitats protection, and promoting a new law on ecocide, although this may run out of road, sadly, before the Scottish parliamentary elections in May. And finally to Wales, where I'm delighted to report that late last night, if you were up watching the Senedd passed a bill to embed environmental principles into Welsh law to set up a new watchdog, which will be called the Office of Environmental Governance Wales, or OEGW for short, and to require new nature targets to be set. It's been a really long time coming. It was promised first 8 years ago, and it's one of the final bills to be passed before the Senedd elections in May. And while the slow timetable has meant a lengthy governance gap, it is heartening that the Welsh Government has been willing to learn some lessons from how laws have been working elsewhere in the UK. So huge thanks must go to the hard-working officials of the Government, the Cabinet Secretary, and a small group of civil society experts who literally have spent years working with us on this bill. Diolch yn fawr, Alex, Annie, Rachel, Rosie and Tess, some of whom are listening online. You can all practice your iechyd dars later, by the way, over drinks, which means good health. So finally, a parting thought then. In conclusion, I think together, and I really mean together, we have succeeded in building strong foundations across the UK with tools and networks for environmental accountability, some of which could be argued to be perhaps better or certainly different to the ones that we left behind. But of course, it would be wrong to pretend that there haven't been setbacks and disappointments, or that the systems are perfect. The environment sector has in the past been criticised for campaigning for new laws and then turning its attention to other things when they're passed. Now is not the time to walk away. We're about to enter a period of unprecedented political turbulence and uncertainty. And while that is, of course, deeply worrying and will be a stern test of our resolve, this group and others like it give me hope that together we can continue to speak truth to power wherever that may lie. Thank you.
Do I just start?
Off you go, Richard.
Oh, okay.
Off you go.
Okay, I'm going to try and time this up. Well, I'm going to talk about the Office for Environmental Protection, which has jurisdiction in England and Northern Ireland, mainly because that's the body I know most about, but we've heard there are similar bodies in Scotland and soon to be in Wales. And of course, I mean, legally, a body such as OEP could have been set up without Brexit. We didn't need Brexit to have it happen, but the politics of Brexit made it happen, so one needs to acknowledge that. OEP has a range of very important functions, but my focus this evening is going to be the use of its enforcement powers to date. I'm no longer a board member, so these remarks are my personal capacity. And my chief executive, former, maybe getting worried, but don't get too worried. Anyway, OEP is not set up to take enforcement action in respect of every breach of law that may have environmental implications. There must be, quotes, environmental law involved, a term defined in the legislation to mean, in broad terms, any law, including regulations, of course, that are mainly concerned with environmental protection. Now, despite that rather broad language, there doesn't appear to have been any real problems of demarcation or questioning to date about whether something falls within that or not. But second, the legislation refers often to serious breaches of environmental law, and OEP's strategy and enforcement policy contains a quite elaborate but pretty flexible statement as to how it determines what is serious or not. But even if a breach is considered serious in those terms, OEP still has a discretion whether or not to take enforcement action based on its own prioritisation. And essentially, one of the key questions it asks itself, faced with that, is will its intervention make a difference? That's often a key question that the board used to ask. Now, as many of you will know, there is a stepped enforcement process: investigation, information notice, decision notice, and an application to the court for an environmental review. And that process is designed, as is the EU infraction process, it's designed to provide the time and the opportunity to resolve matters without going to court. And each of these formal steps, the launching of an investigation or information notice, is made by the board of the OEP, and it can't be delegated to officers. And I think that knowledge that these decisions are taken at the highest level within the organisation, I mean, should encourage, Sally's nodding her head, government and other recipients to give these issues the kind of priority and the seriousness that they deserve. I should say that OEP actually can bypass these procedures in an emergency to prevent environmental damage and apply direct to a court for a normal judicial review. Now, it's threatened to do so only once to date, and this concerned the government in Northern Ireland. It had issued advice to planning authorities on acceptable levels of ammonia from proposed farm stock buildings. And we thought that the levels in this guidance were so generous, much more generous than equivalent guidance elsewhere, as to be Wednesbury unreasonable and illegal. And we actually threatened a JR. We got to letters, protocol letters and all of that. And in what was a very highly politicised issue, for obvious reason, the Northern Ireland government conceded and withdrew the advice, and they're rethinking it now, and without the need for JR proceedings. And indeed, managed settlements have proved the order of the day. No environmental review has yet been taken, and indeed, OEP has resolved most of the cases it's taken to date without even the need to serve the statutory notices, but a much less formal process which it describes as being interventionist, an intervention. And to date, if I've got the figures right, roughly, there have been 28 actions, 22 of which have been resolved, and 6 at the moment remain open. I mean, they're all on the website, you can see it. And the case is split roughly 2/3 England and 1/3 Northern Ireland. And most have involved DEFRA, 15 cases, and the Department of Environment, Food and Rural Affairs in Northern Ireland, 5 cases. The Environment Agency has been involved, 6 cases, Natural England, 2, but local authorities very rarely. And I think that's not surprising, given that actually OEP's enforcement actions is about strategic, big issues. I mean, so I'm not surprised about that. The range of subject matter is very extensive. Examples include failures to meet deadlines in the legislation, waste exports to India, whether they've been properly examined, assessments of financial provision for waste sites, nitrates regulations, NO exceedances for traffic, sewage discharges into Belfast Lock, and classifications of special protection sites, and inevitably storm sewer overflows. And 80% of these cases came from complaints made by the public to OEP, and the rest from the OEP's own in-depth studies on the implementation of environmental law. Now, I think, my own judgment, is that OEP's success to date hasn't been because it's just simply taken easy cases. I mean, the stuff in deadlines in legislation, in law, that's very easy. Many actually have involved very complex and untested issues of law, and there have been many opinions sought from leading members of the environmental law bar, probably many of them here. OEP I've seen many of these opinions. And the OEP's enforcement activities has not replaced environmental judicial reviews by NGOs and others, and nor should it, I think. But I do doubt whether one could have relied, if you look at the range of cases, on third parties to take legal actions in many of those cases it's taken up, and still less whether they could have been resolved by pretty tough negotiation, but without having to get the courts involved. So I think it's a fairly impressive record in a quite short time, especially a fairly small team involved, and the OEP's got lots of other functions, and it's dealing with wholly new powers, which we've never used before. Now, for the future, I think there will be an environmental review in the courts, the first one within the next 2 years, that's my prediction, and I think it will probably be about a conflicting interpretation of law, which is irreconcilable. You have to get to the courts to try and decide what is to do. I think the desire to resolve cases by negotiation will remain dominant, but I think OEP will in future move rather faster to the first stage, the formal investigation. The very informal interventions, which have predominated to date, have achieved results, but they can drag on. And in at least one case, I think NGOs quite rightly criticise OEP for just taking too long. If you start a formal investigation process, it does have a sort of sharper timetable for responses and everything. I think complaints will still provide the source of unpredicted legal breaches, but OEP's implementation reports, and I could devote a whole session to the importance of these, but I won't. But I think they're going to provide evidence, and they already have done, of potential illegalities and grounds for enforcement action. Now, one would hope that government and other public bodies would learn from the experience to date and avoid, for example, missing statutory deadlines, knowing that OEP is going to bear down quite hard on this, and that might be a faint hope. Some of the open cases, such as DEFRA's, DEFRA's alleged failure to meet the 2020 good environmental status targets for marine waters. I mean, these are quite chunky and controversial cases as they pursue. And many of the existing closed cases, if you read the paperwork quite carefully, they're not really closed, because OEP has committed itself to monitoring exactly what government or the other public bodies said they would do to resolve that case, so they're committed there. So I think for the immediate future, I reckon it's going to have its enforcement work cut out. Thank you.
Thank you very much, Richard. So, Sally, I think Richard has really set that up for you very nicely.
Not intentionally.
Thank you, Eloise. Thank you very much for having me. As Eloise explained, my name's Sally Randall. I'm Director General Environment in DEFRA, which is the UK Department for the Environment, Food and Rural Affairs. But as you'll have already picked up from other speakers, the environment is largely devolved, so most of what I will talk about relates to England. And sitting on this panel, and I think as the only member of this panel who's not a professor of any kind, I am not going to try to kind of teach anybody anything about environmental law, but what I will try to do is say a little bit about what it feels like to work within this kind of law in government as a civil servant. So as a civil servant, my job is to deliver for the government of the day, and to do so in line with the Civil Service Code, objectively, impartially, based on evidence, and to advise them on all the different ways, all the different things that they have to consider when they want to achieve their goals. And a key aspect of that in any civil service role is the law. What does the law require them to do? What does the law allow them to do? What does it prevent them from doing? And do they need to change the law to achieve what they want to achieve? That has been the case in every job I've ever done in the civil service. As Eloise mentioned, I haven't always worked on the environment. I've done so for the last 7 years, but before that I spent nearly 20 years working in the built environment, in housing and homelessness and regeneration. And that kind of leads me to reflect coming into this room thinking that environmental law is different, and it plays differently into our day-to-day lives as civil servants to the other law that I have worked with. And the most fundamental difference that in how that experiences my day-to-day life is that the targets of government are written into the primary legislation, or sometimes secondary legislation, but they're written into the law in a way which is just different to any other policy area that I've achieved of. So the law just doesn't set out what government must do or what other players in the system must do. It sets out what we must achieve, and that is a very different way of working to things that I was used to in previous jobs. That is partly a legacy of our membership of the EU, but at the moment that we left the EU, the government of the day decided to embed, strengthen and devolve that approach into UK law. And so I'm just going to say a little bit about the key elements of what has happened there and how it affects our day-to-day work. And Ruth also said a little bit about each of these elements when she spoke. The one that I will start with, because it feels most present in our day-to-day lives, is statutory targets. So everybody everywhere in government is working to goals, to targets, to outcomes, to things that ministers say that they want to achieve. But in many, many cases, those things are up for negotiation whenever the government changes, sometimes when a minister changes, sometimes when a minister changes their mind. And that is perfectly fine and legitimate. But within the environment, they have to do that in the context of a set of targets which are enduring unless and until they ask Parliament to change them. And that makes for a very, very different set of conversations, because those goals have to be constantly weighed up when we are making spending decisions, policy choices. They are constantly present and must always be considered in a way that just hasn't been the case in other areas that I've worked on. The second thing that is really important and present in my day-to-day work is the requirement to publish an environmental improvement plan. So this means that one of the things that we have to do in that plan is set interim targets towards our long-term statutory targets that go 5 years into the future, the same length as the length of the Parliament, and set out the practical things that we will do, a credible set of things that we will do to deliver on those interim targets in the lifetime of this government. And that means that those long-term targets bite on the activities of government right now. So they are not just distant targets, they're things which affect how we must work now. The third thing that I'll mention, which again others have mentioned, is the Environmental Principles Policy Statement, which means that the way that we make environmental policy affects decision making in any area of policy which affects the environment, not just one which has environment written on the tin. And as Ruth mentioned, that has been hardwired recently into the Treasury Green Book, which means that even people who don't spend their day jobs thinking about the environment, it's less avoidable for them to think about that. And then finally, Richard has talked a lot about the OEP, so I probably won't say very much more about that. Maybe we'll come back to it in discussion. But the OEP is now a mature body, which is kind of well embedded into our structures and is something that we think about and something that we engage with a great deal in our day-to-day work. So since that structure was put in place, we have had several new prime ministers, I think, is it 3? And we've had a general election. And those are points when those things could have changed. It is the structure that I've just talked about means that it's harder for governments to change those high-level outcome targets. It's not impossible. They can change the law. That's a thing that governments can do. But this government made it clear from before when they were elected that they intended to lean into that framework. And one of the most important things that my teams have been working on over the last year is publishing a new environmental improvement plan, which I was very pleased to hear Ruth say is improved on the previous one. We also believe it's improved on the previous one by setting out much more detailed delivery pathways towards each of our goals. So what does all of that mean in the context of our kind of opening provocation about turbulent times? So from my perspective, policymaking in this area is not immune to political change, and nor should it be. It's our job as civil servants to serve the government of day, and different governments can have different objectives, and even where they have the same objectives, they can have very different views on the best way to achieve them. But it's also our role as the civil service to be the long-term stewards of public services and of national assets, and to try to balance short and long-term decision-making. And the framework that we have in the Environment Act puts some ballast around those long-term responsibilities and forces us to think a little bit longer term in what can be a very, very short-term world. We in government will be, one of the things that legislation requires us to do is reflect on the success of our legislation every 5 years. So we'll go through a period of post-legislative scrutiny of the Environment Act because we're coming up to that 5-year anniversary. So one of the things that we will be thinking about in DEFRA is has this worked? Has this framework worked? So I'm sure that some people will have views on that and comments and questions, and I look forward to hearing those later. And I've hit 6 minutes, so I shall stop there.
Thank you very much. Okay, note to crowd, questions on the Environment Act for the post-legislative scrutiny coming up. Okay, and Ellen.
Thank you. Thanks, Eloise. Hello, everybody. I've been asked to say a few words about governance in Wales. Many of you will know that Wales is poised for major political change. And on the 7th of May, voters will elect a new Senedd Cymru, a transformed Senedd, representing the most significant overhaul since its creation in 1999. And quite unusually, environmental governance is playing a central role in this, with environmental issues being debated more intensely in this campaign than ever before. Against this backdrop, as we've already heard, the Environment Principles Governance Biodiversity Targets Wales Bill has been making its way through the Senedd, and yesterday was approved, and it now awaits royal assent. The bill, as some of you will know, has 4 parts, 3 of them substantive. Part 1 enshrines an environmental objective and sets out environmental principles. Part 2 establishes the new Office of Environmental Governance Wales, the OEGW, which rolls off the tongue a little less easily than OEP and ESS, and that will oversee the effectiveness and implementation of environmental law in Wales. Part 3 creates a framework for setting legally binding biodiversity targets. The bill, as you've heard, has been a long time coming, arguably too long, and much has already been said about it and written about it. And there are several people in this room who've played a really important role in shaping and refining what that bill looks like and know the detail far better than I do. But in the time that I have, I'm going to focus on 3 themes. The first theme concerns the relationship of the bill with other Welsh legislation and the sometimes utopian idea that these frameworks will fit together seamlessly. But striving for seamlessness may blur, I think, important distinctions in purpose and in design. A key example here is the relationship between the bill and the Wellbeing of Future Generations Wales Act 2015. Now, the Act itself is directed towards the well-being of current and future generations of Welsh citizens. By contrast, the bill that's just been approved is focused on creating institutional structures to enhance and protect the environment. Now, take the environmental objective in section 1 of the bill. It speaks of achieving a high level of environmental protection, but it also, crucially, requires contributing to the well-being goals set out in the Wellbeing of Future Generations Act. Now, those two things are connected, but by bringing them together, there is arguably a risk that the anthropocentric lens of the well-being goals might distort the otherwise distinct aims of environmental protection. Okay, theme 2. The second theme is the assumed optimism around the independence of the OEGW. That optimism may be misplaced. It's important to acknowledge here that the enabling legislation in both England and Scotland does not confer complete independence on their environmental watchdogs either. Even so, I think there's reason to question whether the OEGW would in practice be able to scrutinise Welsh Government effectively. So one example illustrates that point. The bill contains no provision for the OEGW to bring judicial review proceedings or to intervene in them. There's some disagreement about the significance of this and of this omission. The Welsh Government has expressed the view that there's no need necessarily for an express provision to that effect in the bill because the OEGW could in any way rely on its supplementary powers to bring a judicial review challenge if needed. Others, I think it's fair to say, seem less convinced, suggesting that without specific statutory provision, it may be more difficult for OEGW to establish standing, potentially limiting its ability to hold government to account. Now, time will tell, but the concern is real. Environmental watchdogs need not be completely independent to be effective, as we've seen, but they must have sufficient independence and sufficient tools to scrutinise government credibly. The third theme then. Okay, so if the first theme invites us to question utopian ideals and the second asks us to temper excessive optimism, the third turns us to hope. Not naive hope, but a grounded, realistic sense of what might still be possible. So this is not the hope that everything will turn out well. Rather, it's a conditional, sometimes fragile hope that motivates sustained effort to uphold the principles of good administration. The bill itself contains moments of openness that support this kind of hope, provisions that keep matters, as John Dewey would put it, always in the process of being determined. For example, the requirement for Welsh ministers to review the environmental principles statement after each general election, and the requirement to review any biodiversity target that appears unlikely to be met or no longer appropriate. These mechanisms acknowledge uncertainty, and they keep the system alive to change. And beyond the bill, hope may also be sustained by the broader environmental law and policy community, by practitioners, by public bodies, civil society organisations, academics and students, whose scrutiny, research and engagement can also shape environmental governance in meaningful ways. So in these turbulent times, this grounded form of hope matters. It is what keeps systems accountable, adaptable and responsive. And ultimately, it is what will help determine whether the ambitions of the bill will be realised. Thank you.
Thank you very much to the panel speakers. I'm now going to open the floor for questions. I think we have 2 mics that are available. One thing I should have mentioned while you're thinking of your questions at the beginning is you'll see on the slide up here that UCL has the number 200 after it, which Ruth kindly mentioned. It is our bicentennial this year, 200 years since the founding of this great university and this faculty. And this is the 3rd event in our UCL 200 event series in the faculty. So I'm really, really delighted that environment got an early look in the schedule. It's the right order of priorities. But the turbulent thing is interesting. UCL has a history. It was founded as a very radical institution in opposition to the Oxbridge model, where inclusion and opportunity for all was the model for academic excellence. It was founded in a period of turbulence with a radical idea. I also think that's quite astute for this evening's proceedings. So after that little story about our faculty, who would like to ask a question? There's a lot on. Okay, we have a question up the back. It'd be great if I could take two at a time, if possible. So and there's one over here. Thank you very much.
Could they identify themselves?
And if you could identify yourselves, that would be great. But I'll take two questions and then bring it back to the panel, if that's all right.
Thanks very much. Kira Box from Friends of the Earth. I hesitate to ask people for another 10 years on from Brexit, but I wonder if I could ask the panel, in another 5 years, what are your hopes for which elements of the environmental governance system will have been strengthened and how?
Great question. And if I can take the other question.
Hi, I'm Eilish. I'm a master's student from the LSE. My question is a bit specific. It's about Northern Ireland, but it seems that it's lagging behind the other three nations, and I was just wondering what you think the main three reasons for that might be, and also whether that's maybe gotten better or worse since Brexit.
Okay, so I think we'll take those two questions. The first one seems like a question for all members of the panel. What do you think in the next 5 years? And then maybe Ruth, I might look to you, and Richard for the Northern Ireland question. But why don't I start at the end of the panel? Start with you, Ellen.
Sure. What are my hopes for the next 5 years? Well, this is perhaps Wales specific, but not necessarily. Improved protection of funding and resourcing. I think that's going to be quite an issue for the OEGW, and a firmer protective stance of its independence. I'd like to see a more courageous move in that direction.
Sally.
Thank you. I'll give a personal view rather than the government's view, although that's always a fine line to tread as a civil servant. But in terms of strengthening a framework, I'd like to see the framework strengthened by habitual use rather than necessarily legislative change. So we spend a lot of time in government changing the law, which is something that sort of Ruth commented on as well. People often campaign for changes in the law. Legislation like this takes a long time to become habitual in its use, and I think if over the next 5 years it became very ordinary, that would be a good piece of progress.
What are we talking about? 5 years? What did you say, 5 years?
5 year
Okay.
horizon.
Well, I hope the OEP is still in existence.
Low bar.
I hope, I have to say this, but it would annoy Sally a bit, but it wasn't Sally's doing. If anybody, I don't know if anybody's applying to be the chair here, but if they read the terms of reference for the chair, they will see that it wasn't just drafted by DEFRA, and that there was some, I would say, some fairly crude hands by other people saying the chair must have experience of growth and economics. Well, I hope that doesn't, whatever happens on that, it doesn't devalue the growing role that OEP does. But the other thing I would say, and this is again, sorry, I keep going back to OEP, I could do other stuff, but civil sanctions, I want to reform them all again, but that's another question, is that, you know, OEP, and it will still be a tension, it has to fight. OEP's role is not to make environmental policy. That is for DEFRA and government. And in the sense, it has to be very careful where and it will continue. I think that's going to be a very fine balance of getting it right. And even if I take a very crude thing, we talked about the environmental standards, and you might revise them. Well, supposing the standards go down, it's not really OEP's role to say, you know, we will enforce those standards, even if they're basically crap standards. You know, that's our role. Of course, we can, on the environmental improvement plan, to say, well, if you've got standards like that, you're not going to achieve that. But it's a continual, and I think Nat will hopefully nod her head, we have to get that balance right and not overstretch, OEP, because we are not, it is not the government, but it's got a fantastically important role, I think, in governance, if that makes sense.
A few thoughts from me, and I agree with much of what's been said. So 5 years' time will take us to 2031. So Kira, I would really hope we can say that legally binding targets in the environment, like the 2030 target, 30 by 30 from the Montreal framework, that they will have been met. I mean, that's my hope. So let's see how we get on with that. Second, as Sally said, let's just make delivery of what we've already got a priority, and not just for DEFRA, which we know what it is, but across the whole of government. Thirdly, I'd like to see more transparency, and rather than be scared of showing workings about how environmental principles are informing policy. Let's just get them out there, and then probably people like us will stop putting in FOI requests, and we can all just familiarise ourselves with how that system should be working. And then Northern Ireland, a great question. I mean, the system is still quite new. It feels, you know, the environmental improvement plan is kind of just out. So working through that system, getting the principles in to inform how things are working, and landing an independent environmental protection agency, which has been recommended, I don't know how many times, to try and tackle the historic dysfunction in environmental laws. It's not going to be easy, and politics is difficult, but carrying on in that direction of travel might help.
Can I just, on Northern Ireland, and from my name, half of me comes from Northern Ireland, so I'm quite interested. I thought I knew Northern Ireland before we got involved in OEP dealing with it, and it's more than just the ordinary politics. I mean, collective responsibility doesn't work in the same way there. So different ministries are headed by different parties. So, you know, DAERA will not get all the information from the planning and infrastructure. It's actually, that makes it difficult. The second thing I think we found, I mean, I hope it doesn't happen again, but during a period when the Assembly and the Executive were not in existence, we had some really difficult enforcement actions because it was unclear legally how much power the civil servants actually had. I mean, this thing I mentioned about the ammonia, that got caught up in that. And then you've got an extraordinary thing. We talked about the Environment Improvement Plan. You know, the date was there in the Act. So you could say, well, legally, of course they do. But they said, well, we haven't got an executive. We can't sign off our plan legally. And we threatened action. But there's some very complicated case law in Northern Ireland about, even if the Act says that, actually it's overridden by other things. And I don't know whether we would have won that action. I mean, it was worth testing, certainly. Actually, they conceded, and it's one of those situations, I suspect it sometimes happens with DEFRA. The fact that you've got a body like OEP threatening you with action can be actually quite helpful if you've got other colleagues who don't want it. And I think the Minister for the Environment actually probably found what we were doing quite useful because he got the rest of it on board. But it is, I mean, Northern Ireland, and I haven't even got into, you know, agriculture is a much stronger lobby there. There are all sorts of things you can see. I would hope that the next generation, you know, you are from Northern Ireland. No, you're not. Sorry, you were. You know, there is another generation who will say, well, actually, the environment is one of its most precious assets, and I think Loch Ness has actually brought that to attention. A lot of people suddenly realize it's not. You know, it looks, when you go there, it looks wonderfully green, all the mountains, but underneath, I wish I didn't know what I now know.
Okay, more questions. Okay, great.
John,
We have one down here, and we can start with Sonam in the front, and then I will come to you two next. Yeah.
Thanks so much, Gemma Harper, JNCC. Congratulations on the event. It's very timely. I've got a question really for Ruth, but others might also come in. I mean, Ruth, one of the first things you mentioned was national security, and so I'm really interested in your thoughts and others on what you see, both the risks and opportunities of national security being a reserved issue for the UK government and environmental policy being devolved.
And I'll take one more question. Yep.
Perhaps, sorry, I'm Sonam Gordon. I'm a lecturer at King's College London. It's perhaps a specific question for Richard, but I'd be interested in any other views. How do you envisage environmental review from judicial review? How do you envisage the difference between those two in a substantive sense?
Yeah.
Okay. Panel. Ruth, do you want to take the first question?
Thanks for the question. It's a bit of a humdinger of a question, isn't it? But thank you. And for full disclosure, the national security assessment that was recently published was partly prompted by an FOI that Green Alliance put in. So we've got a sort of quite strong interest in this. I mean, I guess I would say that, you know, without information, without understanding the consequences, then it's difficult for a government to take full action. So the fact that that was published is a really welcome step forward. It's clearly not the whole picture, there's more there, but we hope that the whole of government is being, that information is being shared. So there's perhaps a transparency point to what you're asking. But yes, I mean, you know, this is what we wouldn't want that assessment to end up being is sort of lost just in DEFRA. I'm sure it isn't going to be because it's much wider than DEFRA. There's been some parliamentary interest, but it's hard to know what the next steps on that are. So we, you know, maybe Sally's got some thoughts on this as well. But you know, it was a great step to get the information out there. but how is that now going to be used? Because it's clearly put biodiversity loss and ecosystem collapse in a place that it's clear it isn't just about the environment, it's about a lot of other very serious and systemic risks.
Sally, do you want
Yeah,
to speak
I
on
might
this
just
one?
add something on that, which is sort of to get to Gemma's question, which is, I always rely on Gemma for a great question, which is that I think one of the things that Gemma's highlighting is, as well as sort of issues of policy and transparency, when you have some issues that are devolved and some that are reserved, the wiring of government doesn't naturally line up, because you have a community of people in national security who work on a UK basis, and then you have a set of communities of people who work on the policy issues, and it therefore just takes more work and more conversations to connect the wiring behind the scenes in the right way to make sure that that dialogue can happen in the way. And that is not about kind of intent or understanding of those, all of those issues of are people interested, they care, may always apply, but you just actually have to do, when you're working in issues, and there are lots of issues which cross between devolved and reserved issues, then just the wiring's just harder work, and it just takes a bit of work to make that happen.
Ellen, did you have any thoughts on that? No. Okay,
don't.
right. Environmental review?
Yeah.
Yeah.
Well, in formal terms, the environmental review, OEP, doesn't need leave from the court to bring it. And perhaps even more importantly, there are no time limits. We could do it 3 years after the decision, 6 years after the decision. But as a consequence of that, and David, I've heard David criticise it completely, is that the court's powers to give remedies, you know, if say we took an action 2 years after a licence had been given, then the court is almost restricted to giving a declaration, but not to actually cross the decision if third-party interests are affected. It's not quite, it's the balances. Now, I have to say, I'm not too worried about that, because I think, again, this is to the practitioners, if you're trying to stop a particular project in your area, you want to stop a building place to place, you know, basically I wouldn't go to the OEP to deal with that, because the OEP is concerned, in a sense, with principle, trying to get the law right. And I'll give you an example. I mean, half of you, I think, were involved in the Finch case, and we were an intervener, OEP. Well, let's suppose we'd taken the action. Our role would be to get, our most priority, we get a declaration that in future, environmental assessment must take on board climate change. And that's what we'll be looking for. The fact that they didn't actually quash that particular oil field in Surrey on that decision, I think that isn't really OEP's main concern, if that's what the things about the remedies. It obviously is for Mrs. Finch. I think it's Mrs. Finch. You know, she wants to stop there. So there is a difference of approach. I think the really interesting question, because the principles basically apply the same, and David, I'm throw this out to David there to think about this, is that there's clearly, when you're attacking any JR, the substance of a decision, you know, sort of Wensbury type thing, the courts, not surprisingly, do give a lot of deference to the expert bodies, whether it's the Environment Agency or Natural England, or indeed DEFRA. I think what's really interesting, but I was going to say I won't be around when it happens, but in the 2 or 3 years' time, if there is a challenge by OEP on the subject, supposing that ammonia case in Northern Ireland, they can say we got to court, would the court say, well, actually, we don't give so much deference to DIRA because we've got 2 expert bodies who are acting, if you like, not out of any prejudice. They've got their own scientific expert. Will they actually treat it much more equally? And I think that's I don't know the answer to that, but I think that's an interesting question to see whether that happens in the future.
Thank you. I'm conscious there's more questions, so I might move on. I think your references to David to a person who's going to appear on the second panel. Is that right? Who's sitting down in the front of
Yeah, I'm just setting him up, David.
You all get to meet David in the second panel. And I'm not anticipating that your lifespan is limited to the next 2 years, Richard. So I think we can
You never know.
feel reassured about that. So these two, we've got 2 questions. Oh, here we go. Okay, now all the questions are coming. These 2 ladies, yes, young women are the next 2, and then I've got 2 more. Okay, good. I'll come to you. Yes.
Thank you very much. I'm an environmental law student at UCL. I wanted to ask a specific case example. I don't know how much personal or depth of expertise you'll have, but in terms of the management of the Thames water crisis in the UK, as kind of an example of how effectively we actually face kind of practically ineffective governance system on the environment. And Thames Water has been very emblematic on this, and my understanding is there's a obviously there's a new scheme to replace regulator with a new form of regulation, but a lot of environment agencies have come out to call it regulatory kind of capture, and essentially now going to be regulating water companies individually, setting individual targets. So I want to understand from kind of broader legal perspective, agency perspective, essentially the Thames Water situation, what that tells us about the effectiveness of our ability to regulate and take responsibility in the UK. Thank you.
Great. And yeah, if you can pass it down. I'll take 3 questions, all in this cluster. Yeah.
Thanks. Hi, I'm Lucy. I'm from Open Seas. We have a particular interest in the Fisheries Act as a piece of post-Brexit legislation, and obviously it's over 5 years since that was passed, and our concerns are to some extent around bits of that act not being operationalised as we would have expected. So I wondered if you could share a bit more about the post-legislative scrutiny process, the role that can play, the opportunities it presents, and potential risks linked to that. Any comment on that theme would be fab.
Great. And I'll take 3 questions. Yes. Well done.
Nigel Haig, IEP. A source of turbulence since Brexit is the devolution of powers that the environment has now devolved issues. And in practice, it wasn't when we were members of the EU, because most legislation was derived from the EU, which had to be negotiated by central government. Does anybody on the panel think that the terms under which all environment matters are devolved needs to be revisited? If you take Germany, which is a federal country, the basic law there says that air pollution is a federal competence and water pollution is a shared competence between the federal government and the Landa. In the United Kingdom, air pollution is devolved. The Scots can have entirely different air quality standards from the English, and air blows around. Does it make sense? Should this be revisited?
Great question. Okay, I'm going to turn to the panel. I think pick your question that you would like to answer. I'll start with you.
Very quickly, Thames Water, go beyond Thames Water, the whole sewage crisis, it's absolutely a regulatory failure. There's new water legislation on the way, including a water regulator, that will need to be watched very carefully. PLS of the Fisheries Act, really great question. My question is back, where is it? Because it's overdue. It would be great to get a timetable on that. Similarly with the Agriculture Act and devolution powers, absolutely, Nigel. You know, there are lots that need to be thought about. There's still a governance gap in relation to Wales, even though we've just had legislation passed, because the Welsh Government has limited competence in what it can cover. And the deposit return scheme and how that would work across the UK is a good example of some of the complexities.
Okay.
Well, just to quickly
Brief
on the devolved thing. I mean, when the whole idea of an independent supervisory body was being thought about, post-Brexit, I mean, the original idea, and Michael Gove wanted, ideally, to have a UK-wide body, so you could look at all these things. That doesn't quite deal with your question, but at least actually pick up there's a problem going on there, which is affecting. No, not surprisingly, the Scots certainly weren't going to have that put on them. And Northern Ireland said, yeah, you take us on. And Wales has gone its own way. I would say that on that thing, there's one case in the enforcement action on sites of special scientific interest, or SPAs rather, where we thought there were real problems. We managed to get the Welsh body, which didn't exist, but the assessor, and the Scottish, and we all launched, was it investigations or something, on the same day. We did coordinate that, because we thought, well, this actually is a UK-wide matter, in a sense. So we got around that, if you like. It was quite an interesting one. It all came on the same day, a press release, and it's still going on, I think.
Sally, Thames Water, PLS?
Yes.
Subsidiarity gone too far?
3 great questions. So I won't comment on any specifics to do with Thames Water, as you would expect, but I think the government's been clear in the Water White Paper that they don't think that the current system of regulation is effective, and that is why there is really fundamental reform underway for water regulation. So I think the simple answer is that not just Thames, but an awful lot of things that we've seen over the water sector in recent years have convinced government that there is a case for reform. On devolution, I think, does devolution make life more complicated? Yes, it does. I think there are obviously political judgments at play into when that is worthwhile and when it isn't. What I would say is that there is a huge amount of work, some of which kind of Richard has mentioned, where the devolved governments work together, and that is particularly true. Sometimes they don't, and that doesn't, particularly when there are different political parties on top of the different governments, and that can play out, and we've seen that in some examples. Where I think it does work quite well is that our expertise is often quite shared, and Jem is here from JNCC. The J is for joint, and that reflects the joint science work that goes on between our governments, and that helps, I think, to mitigate some of the tensions and to find connections. And we often find connections where there are political differences at the top. You can find connections and make sure that you're sharing expertise underneath. Post-legislative scrutiny on the agenda for this year.
There we go. Nice, easy answer. Do you want to comment particularly on
Yeah,
that
just
final
quickly
question?
on the devolution and turbulence point, which I think is a brilliant one. I suppose what I would add is that the turbulence is not just coming from the fact that the environment is devolved. It's also because issues of justice and the preservation of England and Wales as a single jurisdiction is reserved. And so I think that's where some of the turbulence sort of arises. And I think that's been a real point of contention in recent years.
Okay, I noticed one urgent question over here. It's going to be the last round. One here and one here. Last two questions and the panel will close.
Thank you. It's David Bullock from IEP. Sally quite correctly said that perhaps a little bit surprisingly since Brexit, England and other bits of the UK have expressed quite a lot of environmental legislation in the form of binding targets. And it was encouraging what you said about that. So this raises the question of how and who tracks progress against those targets. This is a very important form of compliance, And the Commission in Brussels will do a number of things. They can ignore what member states are doing. They can take them to court. They can conduct their private studies. They can and do have little expeditions to national capitals and have bilaterals behind closed doors. The OEP and counterparts have taken quite a lot of interest in targets. But what really is the ideal relationship there? Should the OEP see this as part of their central role? Should they, or rather than doing that, should they actually try and enable the conditions such that other people can do that so it's apparent? What do you see as the right dynamic and roles there?
One more question.
Hi, Colin Church. I'm the Chief Executive of the Institute of Materials, Minerals and Mining, and I'm also the Chair of the Green Alliance convened Circular Economy Task Force. So several people have talked about the title or bits of the title, and one of the questions that occurred to me from the conversation, and it kind of builds on some of the other things people said, is the Brexit bit. So I would be really interested in the panel's views. Richard said we didn't need Brexit to develop this context, I think. But are we better off than if we had stayed with the systems that existed? I'm trying to set aside the sort of pure Brexit, hate it, love it kind of thing, but is this system better than the one we would have been working in, or worse, or just different?
So great question to close on, and I'm going to ask each panel member to figure out what they want to say in relation to those two questions and or give their concluding comments. Ruth, can I come to you first?
Yeah, absolutely.
Yes. Yeah.
So I'll maybe answer Colin's question. I think it is different, but there are definitely, in my view, things about our new system that are better, if I can put it that way. And a couple of examples. If we suddenly rejoined the EU tomorrow, which is very unlikely, would we still want to retain a body like the OEP in our jurisdiction? I think that we would, because it's made a kind of a big difference, and you could see how that would work even if we were part of a supranational system again. Public money for public goods in relation to farm payments is clearly a huge step beyond the common agricultural policy. But for me, the biggest difference is where we started tonight, really. These systems, these laws, are much closer to us than they were when we were in the EU. We know the laws better, and we know the people looking over them. We are mainly in this room. So I think that proximity gives us a better understanding and an opportunity to shape and challenge those kind of processes.
Richard.
Very quickly on the targets, the binding targets, I think one of the challenges for OEP, it is taking interest, and clearly it knows, once the date's passed, that's illegal, and it's got jurisdiction. But at what point, if you can start to say it's inevitable you're going to miss this 2 years ahead, is that appropriate then to start sort of enforcement action to get it going or something. And that's quite an interesting legal question. I think the second, the sort of general point I want just to make, again, about OEP. I mean, the OEP, together with the Scottish and Welsh equivalents, it now joins just a handful of independent national audit bodies, I'd call them, in the world, which are set up with enforcement powers to ensure that public bodies comply with environmental law. And there's only, I won't go into detail, but there are about 3 in Europe which are equivalent, but most countries don't. And ironically, because of Brexit, my German and environmental law friends are now saying, we need a body like this in France and Germany. We haven't got anything, and we can't rely on the Commission to do everything, and it shouldn't be doing everything. So as the most recent body, I know that OEP's progress is being watched in interest in other countries, both within the EU, outside the EU, the European Commission, United Nations Environment Programme. And this is really a message for you, Sally. I mean, government and other public bodies, I'm sure, do find its presence annoying at times, and that's part of its function. But I think, given the international interests, my own view is that government should also be very proud of its existence and the achievements to date. And I think it's an innovative and quite significant model of environmental governance that could provide inspiration to many other countries, and government should be actually proud of that. But I don't see that.
Okay, Sally, your own views. Yeah.
Thank you. I will answer Natalie's question rather than Colin's. Sorry, Colin. Not Natalie's question, the question about Natalie, really, about the OEP, question from over here. What is the right role of the OEP in scrutinising government delivery and targets? Well, actually, looking at our delivery against the Environmental Improvement Plan is one of the very few things that the OEP must do under the Environment Act. So, as Richard has explained, the OEP is actually quite a permissive remit where it makes a lot of choices, but we go through an annual cycle where we in government must produce a progress report, and the OEP will respond to that, and they consider whether we've made progress, and we go back and forth between us in that process. And we've now done 3 of those. We've been through 3 of those cycles of doing it. So I think it's clear in the law, it's the expectation that they should be watching us very closely. And as kind of Richard alluded to, I think it's also right that we're conscious that the OEP aren't just looking at have we achieved, they're looking at are we on track to achieve, and therefore kind of sending across warning shots when they believe that government isn't. And that feels to me to be an entirely appropriate part of OEP's role, not just to wait until we reach a point where one of those targets hasn't met. But it's kind of, I think that's hardwired into the OEP's role, that they should be raising the flags when they think that we are not on track to meet, and that is one of their statutory roles to do that.
Final word, Ellen?
Great question about Brexit. I think it's all of those things. It's better, it's worse, and it's different. I think our job now is to focus on the possibilities and making things work.
That is a wonderful note on which to end this panel. Can I ask you to thank the panel members for their contribution?
Well done.
Great.
I've got a mention that I've got the board made a decision. We don't grow by our successes. But I think the next thing I'm doing, so I've done it after my own run. I've put together all the cases that come out from the environmental planning. I don't think people know what it's done. And it's quite impressive when you go through all the detail. You know some of it. The real challenge is actually be talking to the board or not.
Yes.
You just sort of say, I don't think you can.
All the way through that first round, I was thinking, don't forget to get.
Thank you. Nice to see you.
Sorry. There's more. David, you can sit down having a
Oh, thank you. Oh, that's fantastic.
I know, right?
Even better. I'll have to sit across the table. Thanks very much. Thank you.
Really, these microphones working? It doesn't seem to be doing much amplifying, do they?
I don't know. I think you need to be quite close. Quite close. That works.
Okay.
They do. They work if you're close. I'm just not saying. I'm just.
Oh, wow, look at that. There's an actual natural lull in the chat, which gives us an excellent opportunity to ride in with our second panel of the evening. Thank you very much, everybody. My name is Estelle Hon, King's Counsel. I am a barrister at Cornerstone Barristers, and I am delighted to be chairing this second panel, kind of picking up on the speed and on the thoughtfulness and on the interest that we had in the first panel and building on that, and looking at environmental law and accountability. And when I was thinking about our particular elements of this topic this evening, it occurred to me that what we're really going to be discussing between us is the environmental rule of law, is the application of core rule of law principles like clarity and stability and fairness and accountability within the legal system to the context of environmental protection. Because in essence, environmental rule of law bridges that gap between having strong environmental legislation on the books, between having a strong governance system on the books, and actually achieving environmental outcomes through that system of laws. Now, Sally said that this government made it clear that it intended to lean into the current environmental framework, but in a way in which possibly many in this room, and indeed outside of this room, didn't anticipate. There has been rather strong political mood music straining against the environmental rule of law succeeding. And so that's really what this panel is going to be looking at. So we're going to kick off with the mythical David, introduced by Richard, and now fully introduced by me, David Wolf, King's Counsel from Matrix Chambers, an environmental law barrister, who'll be looking into the role of the judiciary. And then we're going to move on to Jake White, who is the newly minted Associate Legal Director at the Wildlife Trust, and he will be looking into law and civil society. And then we will end aptly with Professor Maria Lee, Professor of Law here at UCL, who, as the best films will always do, will end with a musing on the title. We'll end with a musing on our overarching thoughts about law governance and political turbulence. So as with the previous panel, each speaker will speak for about 6 minutes, and then we'll have a facilitated discussion. So David, I'll start with you.
Thanks, Estelle. I congratulate UCL on fantastically appointing itself as the UK's environmental super regulator through its annual event, which continues to go from strength to strength. Which also has a fantastic opportunity of giving me a chance to be, on an annual basis, a bit cheeky and a bit provocative. So bear that in mind in what I'm saying, please. So my topic is judges, as Estelle rightly introduced, and I am interested in judicial confidence and the extent to which we have judicial confidence and the extent to which we need a bit more of it. Now, bear a thought this week for the judges of the Supreme Court of America, who, having been appointed by Donald Trump, were then slammed by him, told they were disgraces to their families, indeed, for disagreeing with him. So that is judicial confidence. I hope they are not going to be cowed, and I hope our judges would not be cowed by that kind of experience, because we need our judges to be particularly confident, because, as we know, in so many spheres of what we're talking about, and I'll come to some of them in a moment, the judges are, they're the ones that the OEP will go to in the long stop. They are the ones that are holding government to account, and so on. In the end, they are part of enforcement. And everything I do, I'm basically a litigator, everything I do is about enforcement, and the judges are key to that. I want to just analyse that slightly. Areas in which judges are confident and less confident. Our judges in the UK. Judges are confident when it comes to questions of statutory construction. Ask a judge, is chicken manure waste? You get a clear answer, they're brave on that. Ask a judge, what does the needs of the crop and the land mean in a waste management solution situation, and they will be confident on that. Ask them whether the decision maker had enough information to make the decision, and they'll be confident. I'll give some examples of that. Climate change. Judges have been very brave on saying government ministers did not have enough information to make decisions around their annual Section 14 net zero and climate delivery plan reports. Judges were very brave in saying that the the minister didn't have enough information about the heritage impacts on Stonehenge when he decided to put a road underneath it. They were very brave when it came, and I was in court this morning in Belfast, literally on this case, where the court is being very brave, very confident on saying that the minister did not have enough information to decide that the biggest road scheme in Northern Ireland is consistent with meeting their climate change targets. The judges, are very confident when it comes to sufficiency of information in that kind of way. But they are much less confident, and I'm going to identify two areas. One on enforcement. They are terrible on holding regulators to account. Yeah? Anybody who watched the programme, the Dirty Business programme that's been going on this week, will see the horror, the shock that is the Environment Agency's approach to enforcement over years. One of my clients, River Action, litigated the Environment Agency's approach to manure management on the River Wye a couple of years ago. And the judge started off, I'm literally going to quote you a bit of the judgment. He said, the court will afford a broad margin of judgment to the responsibility of enforcement provided by Parliament and the expertise of the regulatory authority, etc., etc. Now, if you've watched Dirty Business, you'll know quite what that leads to. And the judge found the Environment Agency's policy on enforcement to be lawful because the policy was that in the event of further non-compliance, enforcement action is not precluded. Right? Further enforcement action is not precluded. That's outrageous. That is setting the bar so low. And that is not an area where we're talking about technical expertise or scientific judgment or whatever. It's about how the courts approach enforcement. Another area, Ofwat. Ofwat had environmental regulatory powers since 1994 and did nothing about it, absolutely nothing about it. You can do an EIR request on Ofwat's files. You will not find mention of the urban wastewater treatment regulations or directive environment components in their files from 1994 until Wild Justice brought a case against them. And then they mentioned it once in a document. And the court said that was sufficient enforcement. That's outrageous. That is not confident judging. That is not an area where our judges are doing their job, in my view. The other area is in the boundaries around things like environmental impact assessments and habitat assessment. Some of those things are very evaluative, yes, scale questions, but some of those questions, what is the project, for example, what is the project? That is not totally evaluative. That is very much, from my mind, a question of law for the courts that the courts could be braver on, but they run away from it. Now that became, interestingly, unravelled. You'd always hear about Finch in these kind of contexts, but unravelled in Finch, because the issue in Finch, as you know, was whether the Scope 3 emissions were in or out of the indirect effects for the purposes of EIA. Now, that had been regarded in the High Court and the Court of Appeal as an
targets in the Global Biodiversity Framework under the CBD, the Convention on Biodiversity. We've got an environmental improvement plan which sets out interim targets and a pathway. I think we also know, thanks to the OEP's most recent evaluation, that we're off target. And so I think my sort of framework sort of observation is kind of answering a question about sort of what has environmental governance done for you, the sort of Monty Python question. And I think there's that endless leaning in government towards deregulation. And with all of that in mind, it seems to me that therefore accountability is all the more important, and that pushback on accountability from government is all the more concerning. First, to start with some pros, I think there are some positives, as I think Ruth was also pointing out. I think environmental land management scheme, the public money for public goods in relation to agriculture, is positive. It is very difficult to see government ever having had either the competence or the will to introduce that whilst we remained a member of the EU. Yes, there are problems. Yes, it's underfunded. Yes, there are design and implementation flaws, but it offers a platform to build on. It signals and it helps to drive the agricultural transition, which we know we need. Is this governance? Maybe not, but it is Brexit related, it's important, and I think it's broadly positive. Next up, OEP. I don't think I really need to say a great deal more than what our colleagues have already said. I think the rigour and the transparency that the OEP has brought in their oversight function has been enormously significant. It has also been the target for civil society complaints, to focus a bright light on breaches of environmental law. And that has enhanced accountability. Although the process has not necessarily been rapid, it has nonetheless led to positive results. And we know that the OEP has played an important role also in its court work and in interventions. Yes, we've lost infraction fines, but we've also gained a new level, a new tranche of environmental regulation, and that's positive. Next up, principles. Again, I think Ruth has spoken to these to some extent already also. I don't think government, with the best will in the world, and I worked there once, was thinking about environmental principles in the past in the way that it is now. Yes, we know there are issues. Yes, we've seen the Rights Community Action judgment from the Court of Appeal saying ex post facto compliance is just fine, but it still provides a hook for NGOs on which to build an argument, and it opens up the jurisdiction of the OEP where you find an issue. Again, a positive. Section 20 statements. These are the statements that ministers are required to make in relation to bills as to whether they consider the bill reduces the level of environmental protection. Honoured in the breach? Yes, potentially, in relation to the Planning and Infrastructure Bill. And of course, an attempted JR on this failed. But it, again, provides a hook for scrutiny and for accountability. And I think, again, the OEP advice focusing in specifically on the Planning and Infrastructure Bill was enormously positive and potentially helped to bring about further amendments. Quickly, on the conversation with the EU. Perhaps because of, perhaps despite Brexit, this conversation, we have to recall, is ongoing. It has not reached the end of its course yet. We have EU reset talks underway. They will conclude in May, and we know that the dash for growth means government believes it needs to align more closely with EU rules. There are potential environmental positives there. We note there are, of course, also potential downsides in the way in which we've seen the European Commission under pressure from member states seeking to water down certain key elements of environmental law. Cons. On deregulation, I think probably at the Wildlife Trust, my third day in the office, I think towards the top of the list would be the Planning and Infrastructure Act, which I think signals to a greater or lesser degree a way for developers to kind of pay their way out of complying with the habitats regulations. And I think that's enormously concerning. Of course, there are important concessions which were won in the House of Lords. Initially, EDPs, environmental development plans, will only focus on nutrient neutrality, and that's positive. But I think we will need to hold government to the concessions made. The Fingleton Review, focusing on nuclear regulation, you will recall, proposes further watering down of the habitats regulations and impacts on access to justice with changes to cost caps, with a possible proposal to amend the Aarhus Convention if necessary. We know that access to justice is tremendously important in keeping government on its game, periodically simply accessing information and getting transparency, which can be very difficult to obtain in other areas. I want to flag briefly greater regulatory complexity arising from Brexit. And here my card-carrying example is the Internal Market Act. There you'll recall we've got some legislation which seeks to prevent, essentially that evolves, but prevents governments across the UK from introducing barriers to trade. And this has had harmful consequences in the environmental regulation space. Ruth mentioned earlier the deposit return scheme, which has been paused in Scotland as a result of issues with the IMA, and the horticultural peat ban is in a similar box. It's difficult to imagine this legislation ever being passed before Brexit or thought necessary. What it does is ensures that the UK moves at the speed of the slowest. This cannot be desirable. Briefly to round off, I think we see wider scale changes in local democracy, which we need to keep a very careful eye on. See the collapsing of local government into itself. I think we see a shrinking public space for protest. See public order legislation, which seeks to focus on environmental protest in particular, and disproportionate sentences handed out to those who do so. That's my alarm, reminding me I've exceeded 6 minutes. At a time when we see the rise of the far right, accountability is going to become ever more important. Finally then, to round off, to answer my Monty Python question, what has environmental governance ever done for us? Look, despite the many admirable aspects I have mentioned, we remain off course. It does not preclude regression in other parts of government. It does not preclude conflict between various different pieces of policy, which in fact inhibit our progress towards our goals. And in those circumstances, accountability is key.
Lovely. Thank you very much indeed, Jake. And finally, Maria.
Okay, thank you very much. So we're talking tonight about some very hard-won laws. And I think my brief was a bit like Jake's, Monty Python question. My brief was really, what was the point of all that? Was there any point to all that? And I think there was a point. There was a purpose to all this legislation. So I'll start with that, what was the point, and then I'll come to the challenging political context that these governance laws sit in. So what's the point? The governance or framework laws that we have post-Brexit create duties or powers that targets be set or and met, that plans, reports and reviews be carried out, that an environmental principles policy statement be prepared and that it then be considered in policy making, that expert insights from the OEP be published. These duties apply to government, mirroring the old EU pattern where member states were the subjects of the primary environmental obligations. These obligations aren't bureaucratic inconveniences, they support good, democratic, well-justified decision-making. And I think we heard that in Sally's talk earlier, actually. Environmental governance laws, then, they provide a space in which the government of the day, and, you know, that's important as well, the government of the day is required by law to attend to environmental questions in a very particular way. There's a sort of institutionalised thoughtfulness embedded in these governance frameworks. And given the dominance of economic imperatives at its least imaginative economic growth, given the dominance of economic growth, a legally protected space for environmental interests is crucial. These laws also potentially provide a space to speak to power. The Environment Act is actually quite weak on public participation, but even so, the targets, the plans, the reports, the reviews, the expert insights from the OEP, they all happen in public. Apparently not the assessments of the EPPS, but everything else is happening in public. And that publicity provides a public measure against which the government of the day can be held either politically or legally to account. So that's what it's good for. These laws are vulnerable to three connected trends, I think. And if you don't think they're trends yet, they are at least three things we might be worrying about. So first of all, there's a possible sense that some laws matter and other laws don't matter. Secondly, there's a shrinking of civic space for both public participation and protest. And thirdly, there is a clear political backlash against climate and environmental measures. And that backlash is using the same tools as we're using. So these laws in particular, the governance and framework laws in particular, are vulnerable to the spirit of the times, I think, in at least two respects, in terms of compliance and in terms of meaning. On compliance, there was no golden age. Governments have never simply automatically complied with all law. We've always had to think about enforcement. We've always had to think about incentives. But we can't depend entirely on active legal enforcement, especially when we're talking about government. We depend on a commitment to law, or at least on shame at the possibility that you may not comply with law. This isn't a shallow approach to rule of law. This is a really deep and pervasive attachment to rule of law values that have been coming up all evening. Law matters. And when that attachment, when that deep rule of law commitment is fragile, and I think it is fragile, even bare compliance with the law becomes effortful for outsiders to ensure. And if we have bare compliance, that neglects the additional ongoing need to make governance and framework laws meaningful. Converting governance rules into positive environmental action, or even just into that institutionalised thoughtfulness, is as much political as legal. Parliament is at the centre of quite a lot of the Environment Act mechanisms, and there is an expectation that Parliament will make environmental issues matter. If the environment is not politically salient, that just doesn't work anymore. And in any event, salient or not, we also need broader civil society, especially environmental NGOs, to shine a light on this. And we ultimately need the rest of us to care very deeply. So in pessimistic moments, I think I tend to dwell on carelessness about the rule of law, on the closing down of civic space for protest and for participation, on the increasingly powerful backlash against environment and climate measures, and indeed on the weaknesses of the Environment Act in its own terms. But echoing Ellen, hope is not passive. Hope is effortful. You know, it's not a state of mind, it's an effort. These governance laws are quite rightly not above politics, but whatever the politics, the laws matter and they really need our care and our attention. First of all, internally, within government, environmental governance laws empower those within government who seek measured decision-making subject to deep and broad expertise and inclusion. Secondly, externally, environmental governance laws support the people and the organisations who are doing the holding to account of the powerful. Governance laws also make incredibly significant demands on the people and the organisations who are doing that holding to account. And thirdly, law should be a tool for opening things up, not for closing them down. These laws provide opportunities for broader politics to happen, and there is no legal alternative to persuading people that environmental measures are urgent. So to finish, ambitious governance frameworks are, I think, increasingly contested. They are at risk of marginalisation, if not more. Legally institutionalised support for good decision-making becomes even more important, but it's not self-executing. The need for that internal and external attention is perennial, and I'll finish as Ruth started. Now is not the time to walk away. Thank you.
Well, in the environmental arena, we do love a circularity, don't we? So it's excellent to end as we started. You said, Maria, that these laws are a tool for opening things up. And now I have the tool for opening up this panel to our lovely question and answer session. I will do as Eloise did and take 2 questions at a time. Please remember to introduce yourself before you ask your question. And if you're needing some encouragement, then go ahead. I'll take the 2 here and then I'll come to the front. So 2 there and then to the front.
Hi, I'm Odette Chalaby from Landmark Chambers. And David, one to you about the point about the judges needing to be more confident. How can we do that? What practically can be done?
Both questions.
Yeah, and then the second question, Cal.
Hi, it's Carol Day. I work for both RSPB and LEAD-A. I'm sorry, my question is also for you, David. I think because we're in UCL, it's kind of traditional, I think, and with Professor McCrory in the room, to ask about an environmental court. And I'm just wondering about whether that might be one way of making judges braver. And I'm mindful that it might be staffed with people like Lord Justice Holgate or Mr Justice Mould, who came out in recent research as only finding for claimants in 10% of cases, and we would exclude the likes of Lord Leggett, who then of course gave judgment for the Planet in Finch. So I wondered whether any of the panel actually have got thoughts about whether that might be timely, and to follow up with Odette's question is, if not through that, how else can we make our judges braver?
Goodness. How do you make judges more confident? I think there's a big piece about how politicians can make judges more confident. I mean, it's not just us who make, I say that us includes everybody. Civil society can make judges more confident. Politicians can make judges more confident by not rubbishing them, by agreeing with the outcome of their decisions, by not undermining the law in their behaviours. And I suppose we, as this environmental community, well, the lawyers in the room who litigate can do so through the way they act in court and so on. I mean, it's a multifaceted problem. I mean, there are other, you could talk about the Judicial Appointments Committee and who are the judges, those kinds of issues. I don't know how wide your question goes, Odette. And in some senses, Carol, it's the same. Your question is very similar. I mean, I'm a fan of an environmental court in the abstract, in a sense, but I'm also concerned about courts and tribunals that become too specialist and become, they lose their wider perspective and they get bodies of groupthink that can be very unhelpful. And that isn't just about who the judges are, it's also about the general ambiance of the tribunal. And I think your example, I mean, I don't want to pick the names again, but we have good examples of where judges who haven't been steeped in the planning bar have made good decisions. That's not to say judges who have been steeped in the planning bar haven't made good decisions, of course, but I think there's a trend there. If you've spent your life being the government's barrister in the environmental cases, defending all the big road schemes, then it's quite hard to get your head out of that space, inevitably, and that's not a criticism.
Jake, do you want to come in?
Yeah, I guess a couple of points, really. I mean, at least one of which you're going to expect me to make, but I'm going to have to make it anyway. We have to engage the public, because the judges are not immune. They do not live outside society. Yes, we have a series of sort of fictions about how judges are not swayed by popular opinion and by politics and by anything else, but the reality is they do open the newspapers and they do talk to their kids. And we have to mobilise the public. And I mean, my favourite example in this actually is coming to listen to your case, David, in the Court of Appeal on Heathrow. And contrasting a case that I've been involved in with David about 2 years before, and how we'd almost sort of been laughed out of court for sort of having the temerity to suggest that development in some way had to have some sort of bending of the knee in the direction of environmental and specifically climate impacts, to a point in the Heathrow Court of Appeal judgment where the Court of Appeal was so much more amenable and so much more open to the possibility of the arguments being made. And I suggest, because in the intervening 2 years, Greta Thunberg and the school strikes had broken and gone around the world. And I don't think judges are immune to that. That's one quick point. And my other point, I guess, is I think it's possibly a point I've heard David make before, but I do think that there is a kind of a cumulative, a merit in sort of cumulative attempts to burst the dam. And I do think it often takes repeated attempts. And one thinks of Estelle's Finch case, where so many challenges along similar lines had been lost, but it took accumulation of reconfigurations of that argument to burst the dam.
Yeah, never give up. Maria?
I mean, I don't really have strong views on whether we should have an environment court or not. What I will say is that most of what we've been talking about is about the use of law outside of the courts. So the habitual use of the law that Sally talked about earlier, the bringing this law, just making this law work and happen in a day-to-day basis. I think that these laws are given meaning in their day-to-day use as much as they are given meaning through litigation. So I'd just make that point, that it's not just about courts.
Excellent. Next set of questions, starting at the front.
Well, mine's been largely answered.
Oh, okay, wonderful. Next set of questions, along from the front.
Hello, my name is Wendy Lalas. I was a founder member of UCL, so it makes me very ancient. But back in the late 60s, early 70s, there was something called the Greater London Development Plan Inquiry, which went on for 2 years, which is why, incidentally, that structure plan inquiries are conducted in a totally different sort of way, because they never again was going to be a 2-year inquiry. Anyway, the one thing I learned, I became a planner, but I was extremely efficient at cross-examination and all the rest of it. And I started really doing this in the late, say, 87, and it all went well. I was minting it really until 2000, and then by 2007, the 2 local government acts made it virtually impossible for, where you just really have a committee that runs the local authority, and other people just represent their wards. But it was just impossible to make a living. So it was time for me to retire. But nevertheless, you've been focusing very much on environmental law and all sorts of other very important things. But for local people, what goes on in planning is really important.
Okay.
And the structure of local government and the rules there have just made it impossible to protest.
So I discern a question there about the interface between all these systems, especially the planning system and local communities. A question that's close to my heart. Next question. Well, there's one at the back. I think, and there's one here.
Hi, thank you. I'm Annabelle. I'm at Freeth, the law firm. It's been touched on briefly in a couple of things people have said, but I'd like to ask a question about money, I suppose, and what public bodies, be it Natural England, the OEP, the Environment Agency, have to do with the funds that they have, both in enforcement, but also when you're liaising with these regulators about positive environmental schemes and policies and trying to come to agreements. On the positive side of things, turnaround times can be incredibly slow. Is it a problem? Is it an excuse? Is it why courts are taking their approach to holding regulators to account? Is there hope about more funding? And if not, any thoughts about how these public bodies need to manage that? And I'm conscious things like Natural England, they've got now EDPs to deal with. That'll be funded by developers, but there are expanding remits, as I understand it, for a lot of these regulators. So I'm just interested in the context of their budgets, how this will impact things.
Yeah, lovely. Thank you very much. Two very interesting questions. So, the interface between local communities and the environmental system, particularly planning. Maria, do you want to start?
The role of local planning in our democratic system, I think, is way too much overlooked. It's presented as if it were just a little bit of regulation, as if it were just inconvenient, as if it were a barrier to growth, when actually it's really fundamental to how we live. And at its best, it could be, it's almost an ideal vision of democratic space making. It could be a very wonderful thing. It's subject to all of the pressures we've been talking about. It's subject to financial pressures. It's subject to rule of law issues. It's subject to the shrinking of, in fact, it's the medium for the shrinking of civic space in many cases. So, I don't know, I'm supposed to try and say something hopeful. The hopeful thing is that we do have these systems and we need to use them. They may not be quite what we want, but as Ellen said earlier, we use what we have and we try to make the world a better place to the degree that we can with the tools that we have. The money point is absolutely crucial, and I'm surprised really that we haven't actually spoken about it, but I'm sure the others have more to say on that.
Yeah, David, do you want to pick up funding first?
Yeah, so on the funding, yes, it would be great if the Environment Agency and Natural England had more money, but I think that's an excuse, really. Just go back to my propositions about enforcement. We need brave, confident enforcement and regulators as much as we do brave and confident judges. So go back to my example of the case that I described and the River Wye. When the Environment Agency made a big play of the fact that they'd recruited 100 and something new enforcement officers who had shiny boots and clipboards, and they were going around talking to farmers. The problem was that the instructions that those people had on their flip charts were fantastically weak. They basically would go to a farmer who was in non-compliance, who was tipping raw chicken manure into the River Wye, in effect, and they would say, don't do it again, we'll come back next year. And that was it. And that really was it. So they could have saved themselves 99 of those people and just written a better policy. I'll give you another example of enforcement, environmental enforcement. How you enforce against farmers. Henry VIII passed a law in Suffolk and Norfolk that farmers in Suffolk and Norfolk had to grow 10% of their crops had to be hemp, because they needed hemp for the Navy. And in order to enforce this law, they gave an enforcement power to one individual, and this individual was allowed to collect fines from farmers who didn't comply and use those fines for his own personal purposes to build a pier at Sheringham. Now, the farmers were so compliant that he made no money, and that's why there's no pier at Sheringham. So that you can make mechanisms work.
And we knew this panel would come to hemp at some point. So. Jake.
Can I add, there is a pier at Cromer. But I can't speak to the whys and wherefores of that. Only a couple of points. I agree with what both the other two have said. Only a couple of points to add. I think, building what Maria has said, I absolutely agree. The planning system is fundamental to all of this. It's where the rubber hits the road on the environment, and the local democracy aspect of that is absolutely fundamental. And I think, therefore, I am a bit concerned, and I wonder if the environment movement is scrutinising enough the changes to local government that are unfolding right now. That's one quick point. The other point on money is, whilst I tend to David's view, I think there has obviously been a hollowing out through austerity. That's undeniable. The point I wanted to make was private money. Was that what we see through initiatives like biodiversity net gain and so on is that regulation, lo and behold, creates opportunities for a market and for private actors to move money into spaces where it's actually delivering environmental goods. So we should not forget about private money as well as state money.
Yeah, just to add on communities and the interaction with the planning system, it's both a joy and a despair. It's a despair because communities come thinking that they're going to be able to achieve a certain outcome, and the system doesn't really help them with that. But it's a joy because when efforts are redirected, and with the support of the Aarhus Convention's costs regime, communities have been able to have their views channeled into both representations at the committee and at the inquiry stage and before the courts that have a real impact. And so the thing that I am concerned about is the chipping away of the Aarhus costs protections, because that will have a significant impact, yet more impact on what communities can and can't do. All right, we've definitely got time for at least 4 more questions, so I'll take another 2. The one here that I missed before, and then one here.
Hi, sorry Nigel. Michael Nicholson from IEEP.
Wow.
We've taken a bit of a clean sweep tonight. David, you talked about giving confidence to judges. Do regulators also need to be given confidence? Because, as I think Richard was talking about, empowering them, maybe considering civil sanctions reform, and I know Richard's got a long history with that, but you know, do they also need to be given more confidence to use existing powers that they already have?
Nigel, IP again. When Brexit happened, I was predicting that paradoxically people would find EU environmental legislation far more important than when we were a member. And I argued that when we were a member, we just took it for granted this new law had to be applied. After Brexit, it was different. The EU adopted a new directive. The UK government had to either decide to ignore it, to do the same, exactly the same, or to achieve the same ends in a different way. There therefore had to be a debate about that new legislation, which was not necessary before. My question is, was I right to predict the EU environmental legislation became more discussed post-Brexit now?
Super. I'll take the third question as well.
My name's Aidan. I'm a legal graduate from Durham University. I'm here with you, Carla, tonight. My question is for the panel, where there's a lack of a scientific underpinning in the current law, say, particularly in the UTR 2023, we have a habitat target that says we have to restore or create 50,000 hectares of wildlife-rich habitats in the UK. But then the law doesn't necessarily define what restore means, and across the EU and also in the UK, there are like a variety of understanding of what restoration is. Even ecological restoration itself is poorly defined in the scientific academia. And so is there like an assumption in the law that presumes the practitioners or even judges understand what these conceptions mean? And when they get translated into legal literature, does it evolve into something else? Do we still fixate on the scientific understanding, or does the law confer a new entirely different meaning to them?
Super question. All right, David, you gave us a little bit of a soup song of what you think about confidence and regulators. So do you want to expand?
Yeah, well, I think you're absolutely right. We do need confident regulators. I've often wondered about the sort of canons of statutory construction, because Parliament passes lots of laws that somehow there isn't a canon of statutory construction that says we really mean it. And I think section 1 of every act should be, when we say achieve this, we actually mean it. You know, when we say stop doing, you know, we have to meet that matters, and we miss that. And I think judges and regulators are part of the reason we miss that. It's essentially under enforcement of what parliamentarians ask for. I mean, water industry is a good example. Lots of legislation in water, just they keep passing more law. We don't need any more law. We just need to enforce the law we've got.
Yeah.
And it's almost as if passing more laws is a sticking plaster, an excuse, an admission of failure in what we've got in all of those respects. And regulator confidence, I think, is absolutely crucial to that. You're absolutely right. We do talk about environmental law more post-Brexit than we did before. I mean, that's slightly Ruth's point. Is that a good thing? Will we still think that's a good thing when most of the law that we have is embedded in statutory instruments that can be swept away by the pen of an incoming party, or we won't names, Secretary of State for the Environment? Will we still be saying, thank goodness for the halcyon days, Ruth, when we were able to make our own laws? I'm not sure we will. I think we might miss the days when there was a backstop. So I think it's, you know, time will tell on that. I mean, your point, in a sense, comes back to my first question, which is what do we mean? When we say restore, what does that mean? And so there's an issue. Parliament has to frame laws that are understandable. Judges have to get into the mindset of using science a bit more, which might go back to the environmental court point. We don't have a habit in this country of courts being creative in those kinds of things. Maybe we need to be, and if you have laws that are framed around those kind of words, our history has been that they get interpreted in very sterile kinds of ways, in planning cases mostly brought by housing developers, frankly, you know, all those kind of words around development plans and so on, haven't been imaginatively and helpfully interpreted. And we need a body of judges and planners and so on who are going to be more embracing of that kind of thing. I've come back to my experience in Northern Ireland at the moment. I'm in the middle of this case in Belfast where this judge has just really got his head around the idea that the Climate Change Act in Northern Ireland, which is much better than the UK-wide one in all sorts of ways, really matters. It really matters, and he really cares about it, and he wants it to be properly enforced, and he's interpreting the words in it consistently with a sort of quasi-scientific approach. So it can be done. It absolutely can be done across all of those actors.
Jake, do you want to say anything about civil sanctions?
I don't have a great deal to add to what David said, to be honest. I do think Ruth's starting point, which was the sort of wider political debate around the value of regulation. Regulation is a hindrance, regulation is a burden, goes to the regulatory confidence point. So I think the rhetoric and the framing also bleeds into that. I strongly agree that whilst we're talking more about environmental law, it's a whole lot more vulnerable than it was before. And on the science point, I don't know, I find some environmental law immensely sort of technocratic. And I find some environmental law quite qualitative and evaluative. So oddly, actually, I think it varies quite widely. When you're talking about what is an indirect effect, there's this huge range of interpretation. When you're talking about parts per million, or when you're talking about air quality thresholds, for example, which are based on absolute kind of crispness, you're dealing with a very different kind of law. So I think in a funny sort of way, maybe environmental law embraces both kinds and both variants of sort of scientific resoluteness, robustness.
Right. So on the meaning of law, all laws, however they're framed, whether they're really technocratic or really open or whatever, all laws have enormous areas that are open to interpretation, always. And hardly any of those things that are open to interpretation end up before a court, let alone the Supreme Court. So those decisions are made as we use the law. They're made in government offices and in the offices of businesses as they make decisions using the law. And that's why we need environmental civil society in those rooms. We need environmental civil society interpreting law in the doing of the law, not just when we get to court, also when we get to court, but not just when we get to court. So it's a really good question, and I think it's a bigger question than a question about science. I mean, a couple of things. So the EU issue, I mean, the EU really isn't what it was in 2016. That's part of our challenge, isn't it? The challenges that we face in the United Kingdom are being faced pretty much across the world. And the pattern of politics in the European Union is at least as polarised as ours, and there is at least as significant a backlash against environmental and climate measures as there is here. So that sort of EU-UK conversation is a completely different conversation from what it was 10 years ago, I think. I don't know if, I mean, sewage is clearly a regulatory failure, but it feels like it's much more than a regulatory failure. It feels like a failure of our sort of economic and political system as well as a regulatory failure, but that's a whole different kettle of fish. I'd be really remiss, given that we've been talking about planning, if I didn't say that in a week's time there's an event upstairs on the Planning and Infrastructure Act, if anyone's interested. But sorry, that's just...
No, that's brilliant. Just to weigh in briefly on environmental law and science, because it's one of the things that I find gives me a bit of confidence as an advocate, that we can put certain understandings before the court. Now, you're right that sometimes there's a difference of opinion, but there are times when you can stand and say the judge can be confident because the science is before the court and because the science says what it says. And I think a thing that would make things much better, and it's something that I'm trying to work on with the Bar Council, is if our judiciary just got a little bit of competence training around climate and nature science, which does happen a bit, but doesn't necessarily happen enough, because I think that would be one of the things that might give them a bit more confidence to make the decisions that we think are the obvious ones they should make. All right, we've got 5 minutes left, everybody. I'm going to take, oh goodness, I'm going to take one more question. I'll take one more question, and then I'll let the panel wrap up.
Hi, my name is Gavin. I had a question. It's more related to the turbulent times aspect of the title. In kind of describing the polarizing politics, how important is it, do you think, for people involved in environmental civil society to lend a hand to other aspects of, say, the shrinking of civil society? And, you know, obviously this event was very focused on environmental governance, but, you know, is there a case to be made that says we should all really be focusing on other aspects of political activism at this stage in order to avoid, you know, the potential government incoming and things like that? And how important do you think that is?
Jake, I'll start with you.
Feels fairly pointed to me, doesn't it, that one? Yes. I don't think I'm telling tales out of school by saying that's very on radar for most of the Green Movement, I would say. So I think there is a sense that the rise of the far right poses a potentially existential threat to environmental protection regulation in this country, and that if a political solution cannot be found or mitigation of that threat cannot be identified and succeeded in, then we're all in for a very, very difficult time. So I think the exercise or the activity that a number of green groups are engaging in at the moment is thinking through what the best counter-narratives are to mitigate, to not to confront, you don't charge the elephant, not to confront, but to tackle the rise of the far right and the sort of divisive, blaming, othering messaging that it relies on. So I think there is probably more going on behind the scenes. There might sometimes appear, but I think it is an absolutely strategic level risk to environmental governance in this country, yes.
David?
Right.
I mean, yes, I do agree with you. I mean, I think I don't disagree with Jake about providing alternative narratives and alternative ways of thinking about the world. But there's also something which we've been talking about all afternoon, which is about using the laws we have that are part of a rich, open, democratic system. You know, I don't think it's unfair to say that civil society has neglected the participatory pillar of the Aarhus Convention, for example, understandably. And I suppose that leads to another response to your question, which is that environmental civil society is pretty stretched thin already. And, you know, the broader sort of movement for democracy and, you know, liberal values, you might even call them, might usefully also think about the environment. I think working together is really important, but it's absolutely central.
Super. And any final thoughts that anybody on the panel wishes to voice?
Keep doing this, UCL.
Magnificent. So yes, thank you very much indeed to my panel. Thank you very much to everyone here. Thank you to UCL and to Green Alliance, who I'm sure will keep doing this. And thank you to all of you for your engagement. We've heard a lot this evening about quite important big concepts that I think are the things that are going to take us through the next few years: active hope, narrative, and working together. And I look forward to exploring all of those over a glass of wine. Thanks very much.